What's the status now with your cat situation?
What's the status? I've got 12
Yeah.
cats. They're all deemed emotional support animals.
Well, deemed by you, but no tenant really wants
No,
to take somebody
they're deemed by medical doctors. I've got medical doctors' letters.
We're talking about Shamika Sanders. She's not here. Bettina from Keystone indicated they have cut a check in the amount of $1,320.
Starting with Mr. Kloppenstein, who lived rent-free for over a year while his landlord waits to sell their home, and somehow still expects compassion despite owing thousands in back rents. Let's see how the judge handles this.
This is file 20350LT. It's entitled Ronald and Carol Schroeder versus Craig Kloppenstein. This is the oldest landlord-tenant case we have from the COVID circumstance. This was filed as a non-payment of rent case last February of 2020. It was alleged that rent was $575 per month, and it was paid through December of 2019. So the plaintiff is claiming no rent paid through all of 2020 or 2021. We had a hearing at the very start of the COVID circumstance on February 24th. The shutdown actually occurred about March 10th or 11th. So we had a hearing on February 24th. I made a finding that through March of 2020, defendant's rent was $2,300 plus costs for a total of $2,596.50. The date for the writ was by March 5th. Well, the plaintiffs didn't request a writ, and then the stay happened. So we had another hearing in August of 2020 where I made a finding that rent was $2,749 plus costs for a total of $3,090.50 with a writ date of September 3rd. Well, then another stay was entered, and we spent a lot of time on these hearings. And then another judgment entered after that. So essentially, this has gone from stay of writ of eviction to stay of writ of eviction. Deborah Davis was the attorney of record for the Schroeders, and she's since left her private practice and joined the prosecutor's office. So the Schroeders have retained Lance Thornton, who does a lot of landlord-tenant work, and the defendant has obtained the services of legal aid, and Rebecca Johnson is here from legal aid. So right now, this matter is still theoretically subject to the CDC stay, which extends through June 30th. It is a non-payment of rent case. The plaintiffs have been trying to evict the defendant since last February. It's now May of 2021, and he's still there, and there's still a stay in place. Mr. Thornton filed a motion to reopen the case, alleging new issues, which are termination of tenancy type issues, but this is a non-payment of rent case.
Actually, Your Honor, I did not file that. My understanding is that was drafted by Ms. Davis, but signed by the Schroeders, and that was all done before I got involved.
All right, so the Schroeders filed that. Thank you, Lance, on their own behalf. And Lance is here now. I did inquire of Bettina Emery about this last week, whether there had been a request for any financial housing assistance from Mr. Kloppenstein to Keystone. Her indication at that time, I guess this is probably ex parte evidence, we'll see if it's correct. Her understanding was Mr. Kloppenstein had applied for assistance, but the Schroeders were unwilling to participate. So here we are. So Mr. Thornton, I'm glad to have him here. He's an experienced landlord-tenant counsel, and the Schroeders, I think, need some help. So, Mr. Thornton, what's your position here?
Your Honor, I'll address that first, the whole issue with Keystone. It's my understanding that the Schroeders have for a long time now had someone who wanted to buy the home. That's why they wanted to evict Mr. Kloppenstein so they could sell it. The buyer does not want a tenant in the home when they buy it. It's my understanding the buyer wants to live in the home. But so that was from the Schroeder's perspective, I think it was a case of somewhat of a misunderstanding. Keystone wouldn't pay the money unless they would agree that Mr. Kloppenstein could stay, at least for a period of time. And their goal was to eventually get Mr. Kloppenstein out so they could sell the home. And that's the problem that developed with Keystone. I know there are some allegations I interpret from Ms. Johnson's response to the motion that the Schroeders have refused other partial payments of rent or rent payments. They haven't. They tell me they have not refused other than the what's happened with Keystone. Currently, I've advised the Schroeders that I think the best resolution here would be to come up with a date by which possibly Mr. Kloppenstein would move out. And if Keystone was able to pay some of this back rent, which my understanding is there's over $7,000 owed at this point just in rent.
What is the current arrearage as best you can tell?
I've got $7,425 through the end of May.
When was any rent last received?
July last year.
Mr. Schroeder's indicating July of last year, 2020.
Your Honor, I have not seen any ledgers. I know some partial payments have been made, so I would want to see a ledger, but we've also discussed continuing to work with the SARA program as well to resolve this issue.
All right, well, the problem here is the plaintiffs all along have wanted to sell this house. There's someone that's been waiting to buy it since last February, as I understood it, because they were going to move into it. And it got filed as a non-payment of rent rather than a termination of tenancy case. And there we are. Mr. Kloppenstein, here we are under this circumstance. Have you made any effort to try to move?
Yes, Your Honor, I have. Well, first I'd like to bring to the court's attention this fact.
Mr. Kloppenstein, I would advise you to just answer the question the judge asked.
You've got an attorney. I know that you like to represent yourself sometimes. All right, all I'm going to ask you now is, well, have you made any effort to relocate?
I'm trying to answer that. Yes, I have. I actually had a place which I left ex parte communication to you a year ago that I was pretty much hoping to get this trailer over in Centerville. However, even though I pretty much had the place to where I was going to be able to get it, when I called Schroeder's, I explained to Ron, I said, I need a reference for the last several years. They need a document from you indicating that I've paid rent. I said, but if we bring in this eviction stuff, it's going to nix everything. He said, okay. So he supplied me with a one-paragraph thing saying that I've been here for the last 8 years and paid rent monthly. I tendered that to the prospective owner of the trailer park. They in turn called the Schroeders, and from there Schroeders proceeded to run me down. So I got turned down on the place.
Yeah, you left a note on my truck telling me what you were doing, which I made part of the file.
Yeah.
Well, that was a year ago. Have you had any success since then?
I have been out every day looking. My pasture, I've got 3 real estate agents. I've got several other people in the process trying to find a place. There's about a dozen of us that's canvassing and have not been able to find anything. I am at the threshold to where now I'm looking at trying to contact motels to where, if need be and if necessary, I can go into a motel and put my stuff in storage until I can find a place.
Well, one of your problems is your affinity for cats, and it's cost you previous tenancies because you have cats and lots of them. What's the status now with your cat situation?
What's the status? I've got 12
Yeah.
cats. They're all deemed emotional support animals.
Well, deemed by you, but no tenant really wants
No,
to take somebody
they're
with.
deemed by medical doctors. I've got medical doctors' letters, and at the time I signed my lease, I gave the Schroeders a copy of each of those medical letters from my doctors.
Well, nobody wants you as a tenant because they don't want 12 cats or 52 feral cats outside. And so the landlords know of this, and it makes it hard for you to find another place to go. So that's why I was asking whether you had a plan to go with your cats.
My cats go with me in number two. The cats, Schroeders have blown this so far out of proportion. There's no feral cats whatsoever. And there's no cats other than mine, and every one of mine has been fixed. And I've had mine, every one of them, the least amount of time for the last 7 years. Some of them are 15, 16 years old.
All right, well, the issue is you're living there, they want to sell their house, somebody wants to buy it, you're not paying any rent, you're not moving, so we're up against the proverbial rock and a hard place. You've had the benefit of living there since more than a year when they've been trying to get you out because of all these stays. Rent is now $7,000, give or take, in arrears, and you haven't paid any rent since last July, and there you are, and there they are. So Mr. Thornton and Ms. Johnson would like to work out some sort of an accommodation. Now, in the background is Keystone, who paid some of your rent, I think. And now they're saying, well, we could pay his rent, but the landlord wants him to move anyway. So it isn't going to be a eviction diversion. Maybe the money would be better spent with something else. And really, the only way you're going to go out of there is by court order. You've been trying to find a place to go for a year and a half. You've paid no rent since last July. It's now almost June, and you haven't found a place to go. And the only way they're going to get you out of there is to pry you out by your fingernails, and then they can sell the house. But that puts you and your cats out on the street. So I'll defer to you, Ms. Johnson. Do you have any suggestion in light of Mr. Thornton's proposal?
So, Your Honor, after speaking with Mr. Thornton yesterday, it seems like there may be some willingness for all parties to work with this SARA program. It's going to really depend on what type of agreement or arrangement we could reach, depending on the numbers we receive from SARA and regarding what backload rent could be paid, if future rent is available, and possibly determining a move-out date. In certain cases, if a new landlord accepts future rent payments, a move-out date can be set according to the new SARA MISHDA guidelines. I've worked on several of these cases already, but it's really going to depend on what numbers we receive from Keystone to see how and what arrangement we could provide there. We are looking to settle some of these judgments and clear those out, but also make sure that Mr. Kloppenstein is housed as well. So I do think something can be reached, but we have to permit the cure in a non-payment case to go forward because this is not a termination case.
12 support cats? That's a lot, even for someone trying to cope. Sure, maybe the landlord shouldn't have spoken negatively, but what if he was just being honest when asked?
All right, Bettina, do you have any input on this?
If the landlords are willing to participate, we would be able to provide some back rent for Mr. Kloppenstein.
And Your Honor, that's the key. Two issues, I guess: the amount that Keystone would be able to pay, and how long the Schroeders, quite frankly, would have to agree to let Mr. Kloppenstein stay. Just to be upfront, I was waiting through today's hearing, but we will be issuing a notice to quit and heading towards the filing of a new termination of tenancy case unless we're able to resolve and get a termination date sometime in the future as part of these proceedings.
And Mr. Thornton, I would ask that you hold off on that due to SARA funding restrictions on when a new notice to quit could be filed. I don't know how long it would take us to get those numbers, but so that that money could at least be figured out so we can work that out would be in everyone's best interest, I believe.
Well, here's another issue, is the CDC stay expires on June 30th. And there's a strong argument that the CDC, Center for Disease Control, doesn't have the authority to grant such a broad-based stay to prohibit landlords from evicting clients. Some judges in other states are frankly just ignoring it. Maybe even some judges in Michigan are ignoring it. There are at least 2 federal court opinions that said CDC does not have the authority to grant such a stay, and that's on appeal. But the only reason Mr. Kloppenstein is still there and has not been evicted is because there have been a series of stays, either from the Michigan governor's office and then some federal stuff, and now this most recent one. Each time, I remember last April, the plaintiffs were ready to get a writ of eviction as the stay was supposed to expire on April 30th. Then it went to June 30th, and it went to September 30th, and there was another one. The stay kept being extended within hours of when it expired. So theoretically, this stay is going to expire on June 30th. But people are concerned about having a tsunami of people ready to be evicted after June 30th. So I don't know whether there's going to be some other stay, legislative or otherwise, but absent some other administrative or legislative stay of eviction, the Schroeders will be able to ask for a writ on or after July 1st without doing anything. The rent hasn't been paid. I don't have to participate in the program. The rent is way in arrears. There's already been an order. And the only reason it hasn't been issued is because of a stay. Now, as I said, we don't know whether there's going to be another stay. So that's in the background. Ideally, something could be worked out where the Schroeders could get some emergency housing money to pay this substantial arrearage, and the defendant could find a place to go. But he's been looking for a place to go for a year and a half. And he wrote me that note on my truck last spring, and I thought perhaps the problem would be resolved, but it wasn't. So that was last June, and here it is June a year later, and he still hasn't found a place to go. So everybody's backed up. The plaintiffs aren't getting any money. The person that wants to buy the house can't buy the house. So here we are. So what do you propose? You're both talking about some sort of a attempt at a resolution. Could we continue this for a couple weeks and see where the parties are at that time? What's your thought on that, Mr. Thornton?
I can talk to my clients quick. If we could, the sooner the better to get back in, and the least amount of adjournment would be great. We're going to have to make that decision. I understand what Ms. Johnson.
Well, right now, I'm not inclined to grant the writ of eviction. The stay's still in effect. Mr. Kloppenstein has made efforts to get funding. Mr. Thornton did a very comprehensive hearing a few weeks ago with some tenants that weren't paying the rent, and they were making $120,000 a year. And he established proof that they just simply weren't paying. So then finally they just agreed to move. But I think there's going to be at least a good faith showing that Mr. Kloppenstein has tried to get assistance, and for whatever reason, it hasn't worked. So if we adjourn 2 weeks, it'll give everybody a chance to see if they can meet some middle ground. Ms. Johnson, what's your thought?
Your Honor, I would ask for the 30 days because the SARA application has been put forward, and if the Schroeders do decide that they do not want to participate in the program, the funds would go directly to the tenant so that payment could be cured and that a judgment could be resolved. So regardless of if the Schroeders decide to participate in the program or not participate in the program, as long as they agree to accept rent and the cure for a non-payment case as permitted under law, I say we continue and ask for the 30 days so that Keystone can process.
Well, he's already had a year and a half. And so you're right, if he wins the lottery and gets a bunch of money and he just pays cash and pays the rent, then he's good to go till the next month. But then you're waiting for them to not file a writ of eviction. So what you're saying is, we're gonna try to get the money and pay the rent. So please don't file the termination of tenancy. Well, they want to terminate the tenancy. They want to sell the house. And so
Honor,
you want it both ways.
So, Your Honor, I'm very aware of what the Schroeders will probably do next, especially with Mr. Thornton now being involved. I'm asking that the court enforce the cure for a non-payment case that is permitted in non-payment cases. My client's been in part denied the opportunity to seek a full cure in his case.
So, do you think it's fair to deny the landlord assistance just because they don't want to keep a tenant who hasn't paid in over a year? What do you think about this?
Well, I don't know about that. The last order was supposed to enter, we did this twice. We did one in February and then we did another one in August. And by that time, a 30-day extension, the stay will be up. They don't need to do anything. And I suppose if the stay is up and Mr. Kloppenstein pays $9,000, his tenancy is good for one more month. That would get him through June or July. And then the Schroeders are gonna file a termination of tenancy action. So it could stall them through July and maybe into August. In the meantime, defendant would move if he had somewhere to move to. And that is a common refrain. I think I'll get a t-shirt made that said, I would move if I had somewhere to move to, because I hear it every week. Anyway, Mr. Thornton, what's your thought regarding their request for 30-day?
We would oppose that, Your Honor. We might as well file the notice to quit, get that 30-day period running so that we can file the new case. I don't foresee a big payment coming through at this point, and I think the Schroeder's downside is more of leaving Mr. Kloppenstein in there. I believe those 12 cats are indoor cats, and the home is being significantly damaged. Mr. Kloppenstein refused a recent request to go in and inspect. So I'm assuming the situation is not good.
And Your Honor, I would like to correct the record. If 2 weeks is amenable to Mr. Thornton for him and I to possibly work on an agreement to get some numbers from the SARA program so that we can resolve that, I would ask for that. I just know there is a scale order issued when SARA funds and programs become involved, which is something I know courts have been pretty adherent to complying with. I do want to note that the complaints and allegations of the condition of the home were not pled originally. In the non-payment case, my client only refused access to the home because he was not given notice. He is more than happy to allow the inspection and has requested a repair to be made as well. He would just like there to be 24 hours notice for that to be done.
All right. Well, I'm not gonna do anything. I'm gonna deny plaintiff's pro per motion to reopen the case. Plaintiff is free to file a termination of tenancy case.
Your Honor, I would like to ask, is the case technically closed? Because
no, you're entitled to a writ of eviction, but the writ of eviction has been stayed because of the various COVID stays. So my last order, there was one in February, and then there was an order. There is an application and writ of eviction on file from September 4th. So the writ of eviction has been filed and it's stayed pending the COVID stay.
Okay, I just wanted that clarification that we could still file for a writ after June 30th.
It's already been filed. It's already been signed. It's an order that he move, but it's been stayed So you don't need to do anything and let the clock tick to July 1st unless there's another stay. That writ can be then issued July 1st. So at this point, Mr. Kloppenstein, it appears you should make every effort to get out of there by July 1st. They've had a writ of eviction in effect since last September 4th, but it's been stayed by one order or another. So unless it's stayed again, the sheriff could come on the 1st or 2nd of July and put all your stuff out. So I don't think we're going to get any emergency housing money. I don't think they're going to get any money. I think they just want you to move so they can sell their house. So that is stayed till June 30th, till further order of the court. I don't have any way of knowing what is going to happen. These stays have come from different directions. One stay was from the state of Michigan, one state was from the federal government, then all of a sudden the Center for Disease Control issued the last stay everywhere across the whole country, which they arguably didn't have the authority to do, so I don't think that's going to happen again. The legislature, the federal government or the state government could issue a stay, but right now the only reason he hasn't been evicted is because there have been a series of stays from one source or another. All right, I'll leave it to anybody else. You guys are certainly willing and capable of talking to each other over the next month, see if something can be resolved. Plaintiffs are entitled to file a termination of tenancy in case there is another stay. But at this point, I'm not going to reopen the case. I think defendant made a good enough effort to secure funding. For whatever reason, it didn't happen, probably because partially the plaintiffs wanted the money but wanted him to move, so Keystone wasn't willing to do it. So they don't have to take the money. Now, if he comes in with $10,000 cash and pays it to them, then they're stuck with him, stay or not, unless they file a termination of tenancy. But at this point, it's status quo. The writ of eviction was signed September 4th of 2020, and it's been stayed until June 30th. We'll see what happens between now and June 30th. Mr. Kloppenstein, I'm glad you've got legal representation. Legal aid is as good as there is for tenant defense, but at some point the clock is going to stop ticking and the Schroeders are going to be entitled to get their house back so they can sell it. So we've got about a month. I've got other people waiting for their cases.
Your Honor,
So
do you need an order or not?
yeah, that would be good, I guess. Lance, I'd ask you to do an order.
Okay.
Ms. Johnson.
And Mr. Kloppenstein will happily speak after the hearing.
All right.
And
All right.
Your Honor, are you stating that if my client came to the plaintiffs with the money, they would have to accept the cure?
Well, that's a good question because the writ of eviction is already entered. So probably not. If he had $10,000, I've already issued the writ and it's just been stayed. They could decide to accept it, but I don't think they could be compelled to. All right. Thank you. Mr. Kloppenstein will be in touch. Stay in contact with your lawyer. The Schroeders, I'm glad you've got counsel now as well. I know you're very frustrated, and I think there's probably enough frustration to go around in this case. All right, I'll remove the parties one by one.
Thank you, Your Honor.
And now, this one is on Miss Borges, who owes thousands in back rent and is not in the property, but claims she's still open to buy it even if the landlord says no. Let's see how this plays out.
Thank you.
All right, Mr. Richmond,
Yes.
my apologies. I thought you were Terry, T-E-R-R-I Richmond, who I've known for many years, and it wasn't
Yeah,
her
that's my
voice. And I
sister.
don't know if it was some imposter. Anyway, you're Terry, T-E-R-R-Y Richmond.
Yeah,
And
Terry
your tenant-
T-E-R-R. She is my sister-in-law.
All right, I got it straight now. My apologies. I owe an apology. Jessica Burgess is here. Mr. Andrew Rognes is here. This is filed as a non-payment of rent case. And so, Ms. Burgess, I need to advise you of your rights. As a defendant, can you hear me? You need to unmute
I can
your
hear
mic.
you, yes.
All right.
Okay, can you hear me
All
now?
right. Yes, I can. All right,
Okay.
Miss- you have the right to obtain counsel for representation in this matter. You're here as a tenant in a non-payment of rent case. If you cannot afford an attorney, a legal aid attorney may be available to help you. We gave you that information. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is, the Michigan Department of Health and Human Services in our county, that's Keystone Place, or other federal or state agency may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. The summons and complaint from the court are sufficient. If the plaintiff is agreeable, the Citizens and Mediation Service, Inc. may be available as a possible source of case resolution. If the parties are interested, the court can facilitate that. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. This is filed as a demand for non-payment of rent. Bettina Emery from Keystone Place is here on the feed, and Keystone is the agency that could be available to provide some emergency housing assistance. This is a property out on Boone Road, and the rent is quite substantially in arrears. Mr. Rognus, what's the current arrearage?
Your Honor, my understanding is that it's $4,350 that was through April 12th. The rent's due on the 15th of each month, so you now got April. And my supposition is that with the statutory adjournment, we'll probably be back into May. So I thought emailed over a breakdown to the court.
You did. You got through May 5,650. We include April and May.
That's through May 15th.
All right, plus costs.
Correct.
Mr. or Miss Burgess, have you been in contact with Keystone?
Yes, I have.
Bettina, what can you tell us about this one?
I just heard from Mrs. Burgess today, and she was filling me in on the details of the non-payment of rent, and we may not be able to help her.
So you don't know yet?
I do not know yet.
In March, the Supreme Court changed the rules once again and requires that I set this for a second hearing 30 days out from today. So, Mr. Richmond, I don't have any discretion in that matter. Let's find a date that works for Andrew.
And Your Honor, can we get an escrow order in between now and then too?
No, it doesn't allow that. It simply says she's
Mr.
subject to a,
Middleton?
just a minute.
Okay.
That would take us to June 14th at 1:15.
I've got something with Rob at 1:15, but I can bounce back between you two.
Well, how about if I set it, how about we set it at 2?
That'd be even better.
All right, Miss Burgess, is your husband there with you?
No, he is not.
Is he still there?
Yes, he is taking care of our children right now so that I can do the court.
What did you want to tell me?
Now there are other people that are on the property. It's actually my husband's baby mama. They have been harassing me. They have been putting me through hell, excuse my language. I have talked to lawyers. They have advised me that I need to ask my landlord if he could go ahead and evict them because he would have to evict them from the property to get their pop-up camper off the property. They keep telling me that they're going to get it off the property. Just Friday, they said that they were going to get a truck and rent and get it off the property. And then the next day, they said that I have court on Monday, that they don't need to do anything, that it's their property. They are putting me through hell. I just need them off my property. I don't need to deal with them.
Mr. Richmond, what can you tell me about that you're renting a property?
Okay,
and
Your Honor, this morning is Your Honor, this morning is the very first I've heard of this. Now, she doesn't have a place to live there. The house burned. And it's been destroyed, and I need to clean it up. They're holding all of these funds in escrow because I can't clean it up.
So the Burgesses are living in this house?
No, we are not.
I don't think they should.
We are not living in the home. I don't know where. We have our belongings that are on the property. I mean, that was our home. I would like to try to purchase the property, but my co-signer that I have that's willing to co-sign for me will not co-sign for me until their pop-up campers off the property because they're just harassing me.
All right, well, he doesn't wish to sell you, he doesn't wish to sell you the home. So I'm not gonna make her pay rent for a burned out house. When was the fire?
Exactly, but I just want her gone. It's what I want so I can clean up the property.
All right, stop for a minute. When was the fire, Miss Burgess?
February 23rd.
Andy, this sounds like it should have been a termination of tenancy case.
Yeah, except that we would have had to have waited 3 weeks longer on the 30 days for the termination notice.
Well, I'm not gonna order her to pay rent on a burned out property she's not living in.
She was delinquent from the last payment. All of this payment was from July. Last time she was current, that was paid on 11/6, but she was only current back to July 31st. Her payment is $150 a week.
My husband.
All right, just a minute. Mr. Richmond, you haven't appeared here before, but that ain't how it works. You're by telephone. I can't see you. You can't just blurt something out. We're not
I'm
at
sorry.
the kitchen. We're in a courtroom. You have an attorney also that's here to represent you. So, Miss Burgess, you've got your property in a burned out house and he wants you to get your stuff out of the house. They filed it, in my mind, incorrectly as a non-payment of rent case. I'm not gonna make you pay rent after the house burned up. You need to get your stuff out of there, is what it boils down to. Have you made any provision to move anything?
Yes, I have been moving stuff. And I've talked to Terry, and he has said that he would sell me the property. Now, I have a co-signer that would help me so that I could get the money to obtain the property from Terry. But my co-signer will not help me out until these people are off the property because all they are doing are harassing me. And I've talked to lawyers, and they have told me that Terry has to evict them from the property.
All right, that may be true. So, Mr. Richmond, how did these people come to put a camper up on this property you've leased to somebody else?
Like I say, Your Honor, this morning is the very first I heard of it. I got a text message from her telling me this. I've never heard of this before from her until today.
All right, Mr. Rognus?
I thought she said that it was her husband's baby mama living in the trailer or camper.
Yes.
So, I mean, that's really somebody associated with that. My suggestion would be she could just consent to entry of an order of possession and we can get those people out of there in 10 days. They're squatters. She doesn't have anything out to the place that she presumably couldn't move in the next 10 days, Ms. Burgess?
I couldn't. I want to buy the property.
Well, I understand.
All right, if this was filed as a termination of tenancy, Andy, I would only have to set it for 7 days. It was filed as a non-payment of rent case, so I have to set it out 30 days. But I'm not gonna order she pay rent for a burned out property that somebody else is living on. Now, Miss Burgess, how did these people come to put this camper on this property? Did your husband give her permission to put it there?
Well, they were only supposed to stay for like a week or two. And she came, my life's been a living hell. Okay, I have always
so your landlord did put them there with permission.
$5,000.
All right, well.
They are harassing me to this day, and
then,
they need to be gone.
Well, your landlord didn't let them move in there, you guys did. He doesn't even know about it. He needs to get him out of there, to be sure. But I don't know whether he wants to sell you this property or not. But it's filed as a demand for non-payment of rent. I have to set it for 30 days from today, which would be June
14th at 2 o'clock.
June 14th at 2 o'clock. I don't have any discretion in that matter. My suggestion is you get your stuff out of there. I'm not going to issue an escrow order, and I'm not going to make you pay rent for a property that's burned up. But I don't know whether he's going to sell you this property or not. If he does, well, then you can work out some deal between now and June 14th. But you let these people on there. He didn't. And
Yes.
so.
And they will not leave. They will not leave.
All right. Well, you didn't have the authority to bring them in there, and you don't have the authority to get them out. So you've created a giant headache for your landlord. At any rate, you have the right to. I understand, Bettina, why they won't be eligible for any assistance. You're not going to pay rent for a burned out house.
I'll pay to evict them. If my landlord evicts them, I will pay the cost for it.
That's between you and him. This matter is continued to June 14th at 2 p.m. And I'll take 2 Tylenol an hour before that hearing.
Honestly, being harassed by people you let in is wild, yes. But in the end, you really can't force someone to sell if they don't want to.
All right, you're free to go.
Thank you, sir.
Thank you, Middleton.
And here is Mr. Ashford, behind on rent, with a landlord frustrated by the silence and ready to get them out. Let's see how the judge handles this.
Set for 9:10. It's 9:06. And Christian Ashford has just checked in. Mr. Ashford, can you hear me? You need to unmute your microphone. Good morning. This is Judge Middleton. Am I speaking with Christian Ashford?
Yes, you are.
Is Jasmine Armstrong with you?
Yes, it is.
All right, very good. Thank you both for being here. Do you have the ability to do video?
Yes, I do. Just give me one moment, sir.
All right. Ms. Standish, this is a situation where I wish you had Miss Nancy helping you. She's one of the best she and Jordan both are some of the best landlord tenant attorneys we have here in the county. And they help you in a very difficult case, but this case is sort of half one thing, half something else. We'll see if we can figure it out.
And it was, that's my fault.
I don't want to say too much because they're still on mute. Mr. Ashford, could you unmute your mic?
Yes, I am here, sir.
All right. There we go. Good morning to both of you.
Good morning.
Good. All right. This is Judge Middleton. I'm here at the courthouse. We've got your landlord, Robin Standish, and there's also a lady here on the feed named Bettina Emery, who is from Keystone Place. She's our local housing advocate, or one of them. This is a case that has, I can't quite figure out what flavor it is. You got a notice to quit and a demand for non-payment of rent served up you on May 2nd.
I got a picture of it on my phone.
Well, I have it right here. It says you owe $500. So you were served notice as a demand for non-payment of rent. Then they filed some stuff indicating that it's kind of screwy. I can't quite figure it out, but it alleges that there's unpaid rent and fees, but it isn't broken down right. Then they filed a complaint to terminate your tenancy. So they gave you a notice to quit for non-payment of rent and then filed a complaint for termination of tenancy. You're not really supposed to do it that way. And so this is, sometimes you get into problems when you have people representing themselves. And if it is a termination of tenancy, it's for non-payment of rent. And will not respond to landowners by phone or text. If it is a non-payment of rent case, Keystone to help pay the rent. But very first of all, before we start, let me advise you of your rights as a tenant in a landlord-tenant proceeding. Oh, I apologize. I've got bad allergies this morning.
No, you are perfectly fine, sir.
This is, well, it won't be when I start sneezing here in a minute, but we'll hope for the best. As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, or other, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case, that's Keystone, or other agency may be able to help you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance. The summons and complaint from the court are sufficient. If the plaintiff is agreeable, the Citizen Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. As I indicated, this was filed as one thing and then filed as something else. What is it, Ms. Standish? Is it a termination of tenancy or is it a demand for payment of rent?
I apologize, Your Honor. It is a termination for non-payment of rent. I had filed this electronically with her. I filed her taxes and she's been, was communicating with me, and then all of a sudden they just quit communicating. So I have no idea what's going on.
Well, there is no such thing as termination for non-payment of rent. It's sort of half one, half of the other. It's demand for possession for non-payment of rent. How much is the arrearage? I got your breakdown sheet here, but I couldn't quite figure it out. Through July, how much is rent?
Rent is $200 per week, and that includes the electric and the gas and the water.
All right. So how much is
her last payment was paid on April 19th, so she wasn't paid. Rent was not due until the 23rd of April, which was $200, and then every 7 days after that.
Well, how much is the rent? I'm going to ask you this every time.
$2,400.
Through when?
From April 23rd till today.
Is $2,400 in rent. All right. What else is there?
There is $90 in late fees, and that is for April, May, and June.
All right. And you've got a water bill of $188.
That would not be normal that they'd have to pay that, but because of the non-payment of rent, there was no monies coming in on either side. So I have been carrying all of it, including the mortgage. I'm actually in forbearance on my own property because it's on my property because no one has paid rent since May, and she has not paid rent since April.
All right. Well, I talked about the difficulties with this building. All right. So that's how much is due. Keystone could be available to help them pay their rent. In a non-payment of rent case, Keystone could pay their back rent and some prospective rent. You have to agree to participate in the program, and the defendants fill out the application. Are you available?
I have been open for communication. Jasmine is actually a relative, and I have been open for communication. I don't know what happened. They haven't spoke to me or answered the phone, so I don't know what's going on.
Have you done this program before through Keystone?
I have for Lacey.
All right, so
the prior tenant.
All right, the law requires that I adjourn this for a second hearing. In a non-payment of rent case, it's 30 days, and a termination of tenancy case, it's 7. You're interested in getting the rent paid. You gave them a notice to quit for non-payment of rent. So both sides need to get in contact with Keystone, and I'm going to adjourn this for 30 days to August 9th. Let's see what I got. Let me repeat.
Now, Your Honor, I do have one question. So Jasmine had approached me in February, and they were not employed but they were receiving assistance through the unemployment. And so the lease was only till August 26th. I don't know now that I do know that Christian has obtained employment, but I believe it's in Battle Creek. I'm not sure if this is what they want. So I would like you to find out if that's what they want.
What do you want?
Me?
No, Mr. Ashford and Jasmine, what do you want?
Well, my employment is actually in Portage. It's not in Battle Creek. So, where exactly is the Keystone location at, if I may ask?
It's in Centerville. I think we already sent you that information. But let me ask, do you wish to stay there or do you wish to move?
Well, we want to move. We just wanted to get this handled first. And as far as the communication, there was communication almost every 2 weeks, because besides them calling and texting me, her husband was actually watching my Facebook.
Well, that's not much communication, but all right. You have the right to apply for emergency eviction diversion funds, which gets your rent paid and gets your landlord paid. She filed this as a non-payment of rent termination, and then turned it into something else. I'm going to treat it as a non-payment of rent case. Your obligation would be to contact Keystone. I'm going to continue this until August 9th.
We agree.
So once we...
All right, now let me give you this number right now. Do you have something to write on? Nobody ever does.
Yes, we have something to write on.
All right, Bettina, why don't you give them your number?
269-467-7078, extension 1. Huh?
You said your name's Tina?
Yes, extension 120.
All right, now lots of federal money has been allocated to help people pay their rent. It helps the landlord. There's a bunch of problems with this building, and not the least of which is different apartments are sharing water and gas and electric meters, and I've had to try to unscramble this multiple times. Most of the people there want to move somewhere else, but they can't find somewhere else to move to. In the meantime, the landlord's got these apartments that no one's paying any rent on, and then she can't pay her note, and it's bad all the way around. So you need to either move out, or you need to contact Keystone Place and see about getting some emergency financial rental assistance, which could pay your back rent and some of your forward rent. I don't know what your employment situation is and how that will affect it, but I won't know it if you don't apply. Then our next hearing will be August 9th at 2 o'clock. That's 30 days, actually 31 days from today. If no rent is paid at that time, I'm going to give you 10 days to move out or be subject to being evicted. So we will address this matter on August 9th at 2 o'clock and see where we are. Ms. Standish, you may want to contact Keystone also to make sure all of your information is current and correct. We had a guy this morning, he got $6,500, several months of back rent, 2 months of prospective rent. He was quite satisfied with that. So let's hope we can accomplish something like that here, or they'll move out and then we'll worry about money later. All right, in the meantime, this matter is adjourned until August 9th.
Thank you.
Thank you so much.
If you're planning to leave, why not discuss it with the landlord on time and settle the bills? Well, here is Miss Gonzo holding on to a home she legally shouldn't be in. Let's see how the judge handles this.
9:43. This matter was set for 9:40. I'll call it. It's entitled Virginia Mingus and Angela Mingus. Wait a minute, let me make sure I got it right. Virginia Mingus and Angela Mingus as trustee versus Marcia Gonser. This is a property out on Thunderbird Drive. Mr. Robert Brothers is here on behalf of the plaintiff. This is a termination of tenancy action. Notice to quit was served on May 6th. I wasn't clear if there was ever a lease. Was there a lease, Mr. Brothers?
No, Your Honor. The defendant took possession of the property purportedly as the trustee of the Virginia Mingus Trust. And I believe that was approximately 3 years ago. And because of her behavior, the probate court removed her as trustee. So one of the bad behaviors is using trust assets, and the house is a trust asset. So Angela Mingus was appointed as trustee by the probate court. I've indicated the probate court file number in the filings, and so that she had no right to live there in the first place, and she continues to have no right. So Angie Mingus, as trustee of the trust, is pursuing this action to remove her as a tenant at sufferance.
All right, the law requires that I set this for a second hearing at least 7 days away in a termination. Let me see what we got here. In a termination of tenancy case with personal service, I have the right to do a default. This service is by attachment. As far as you know, is she still there?
As far as we know, do you know anything further, Angie?
I don't know anything further. I have not been by there for a week or so, but at last she was still there.
Your Honor,
No.
I'm sorry, the return of service indicates that Mr. Morris went there several times there was a car in the driveway, but the door was not answered. So that is the extent of what we know of whether she's still in possession.
Sergeant Morse does a excellent job, as you know, of serving all our process, and it appears she is still there. Who was Virginia Mingus to Marcia?
Her mother.
Well, the law requires I set a second hearing, whether we like it or not. And the problem, Bob, is I'm on vacation.
Till Halloween.
I felt like being on vacation till Halloween. Maybe that's it. No, I'm on vacation for the next. So my next available date is the 26th of July. And so I'm gonna have to continue this for a second hearing. If we had personal service, I could do a default. So let's set this for July 26th at 1:30.
Very good.
Tenant failed to appear, no personal service. As you know, these family situations can also be very difficult. There's probably also an issue of dissipation of the property and other issues, but we'll set the second hearing at our next available date. And that's the best we can do here this morning. Anything else we should put on the record here?
I don't think so, Your Honor, other than I hope you enjoy your well-deserved vacation.
It's one of those vacations where I do this every summer. I take a vacation and then I stay home. It's part of a plan. All right.
Thank you.
This time, here is Mr. Littlefield, staying in a home with no lease, no rent paid, and the landlord wants him out. Let's see how this plays out.
This is file 21706LT. It's entitled Jeffrey Brown versus Amanda Greg Hilton and Tristan Hilton. Andrew Rognus is here for the plaintiffs. We were here on May 21st. The defendant indicated they planned to leave, and they had no power. They had a generator and they were going to be out. And I continued the matter for 7 days to today, May 28th. You're in the same universal background you were in last time. Today is a week later from last week. Ms. Hilton and Mr. Hilton, what's the circumstance?
We have the house pretty well packed up. We have everything moved out to the garage. We're just waiting for the truck to come and move the stuff from the garage to the storage unit. And I have yet to go to Jeff's actual residence over on Mechanic Street to get my stuff from there.
Well, you have 10 days to vacate. This one, meter with a fire and the meter was pulled. I'm not gonna put you on the street tomorrow, but Andrew, it sounds like they'll be out, but would you submit a judgment?
Actually, I think we emailed it before last Friday.
Oh, I've got it right here. I find by hearing the plaintiff is entitled to possession of the property by June 7th. this is a hazardous property. There was a fire, there's no electricity, you're running a generator, I don't know if there's water. You really need to be out of there. But if you're not out by June 7th, the sheriff will come put you out. I think you will be out by then. I think you've been making effort to get out of there. You don't want to live in a house with no electricity.
No.
All right, if you're out by June 7th, you need to turn in the keys to Mr. Brown, give your forwarding address. But
I was there our last court meeting and I gave him the keys already for the house.
all right, then you don't need to do anything except get your.
Right.
All right, do you have any questions?
No, sir.
Okay, you're good to go.
Thank you.
Thank you. Hopefully they can get out of there and Mr. Brown can get in and make some repairs. All right, our next matter is also Mr. Rognus. It's entitled David Persons versus Jeff Littlefield and all others. Good morning, Mr. Littlefield.
Good morning.
This is also a termination of tenancy case. In this case, Mr. Rognus contends that Mr. Littlefield is a squatter. His father was the tenant. He moved in, father-in-law. He moved in, the original tenant left, and Mr. Littlefield was there with his children. So same thing, I set the matter for a second hearing today. No rent was being paid, and I wasn't clear what the status is. Mr. Littlefield, what's your status here today?
I've been looking for a place. I've been in touch with Keystone. I mean, they were going to pay all my rent for up to like 6 months, but he denied that. But they're still going to help me pay for a place to move to. But I'm finding something.
Is that correct, Bettina? Keystone would have paid rent, but they didn't want to accept it because he wasn't an actual tenant?
Not to my knowledge. We have other case managers here, so maybe he spoke with another case manager, and I'm unable to confirm that.
All right, well, here we have no lease. Mr. Rognus, you're simply asking for possession of the property back?
That's correct, Your Honor. And again, we had submitted a proposed judgment prior to the last hearing.
I have it. Same thing, Mr. Littlefield. You're in a tough spot. You got 4 kids. You're in there. You were willing to pay the rent. They don't apparently want that. This is a common theme this morning. The landlord simply wants the property back. In 2 of the previous cases, they wanted to sell the property, and I believe that's the situation here. I believe Mr. Persons wants to get the tenant out so he could sell it. But we had the first hearing. This is the second hearing. You're what's called a tenant at sufferance. There is no lease. You're a holdover tenant from a previous tenant. You have until June 7th to move, or you're subject to being evicted. Now, let me speak to that for a minute. Keystone is trying to help you find another place to move to. And it's hard right now to find a place to move to, here or anywhere else. They don't have to evict you on June 7th. They have 56 days from today to ask for the writ of eviction. But by the letter of the law, unless you're out by the 7th of June, the very next day they can come and ask for a writ where the sheriff comes and puts you out. You've been there apparently since October when your father-in-law left. The matter's a little complicated because even though there's no lease, they did accept some rent from you. But at this point, the landlord does not want the rent. They want their property back and they want you to move. So you have until June 7th or you're subject to being evicted. I would suggest you stay in contact with Keystone. June 7th is a Sunday, so wait a minute. It's a Monday. So let's say you found another place on June 9th. Well, if you let your landlord know, hey, I'm going to move into my new place on June 9th, there's no sense to go through a whole eviction on June 7th. But what this type of hearing is about is really coming up with a drop dead date for the landlords to get their property back. And I had a case with a gentleman earlier this morning. The landlord's been trying to get him out for 1.5 years. And because of the COVID circumstance, they've been unable to do it. So I'm sorry you're in this position. I assume you want to stay in the White Pigeon area?
Yes.
And that's hard too. There are a lot of people looking for housing. The thing is, every time someone gets evicted, there's someone waiting to move in. I think Mr. Persons wants to make improvements to this house and sell it. But that's the circumstance. You do have 10 days also to appeal this. If you appeal some issue that I've not seen, you could still ask for counsel, as I told you last time. Do you have any questions?
No, sir.
All right, you have 10 days to move or you're subject to being evicted. All right, good luck, sir.
Finally, this one is on Miss Sanders, who didn't show up to court despite getting rental help that still didn't cover all she owed. Let's see how this plays out.
This is Judge Middleton. Can you hear me?
Yes.
We're talking about Shamika Sanders. She's not here. Bettina from Keystone indicated they have cut a check in the amount of $1,320.
The process.
It's in the process. Edgewater has yet to receive any check.
Not yet.
What's the arrearage now through June?
Showing a rent to retain possession of 1,270, costs of 166.41 for a total of 1436.41.
I don't have a judgment. So I'm going to, and Shamika isn't here. She usually shows up. I'm suspecting maybe that she thinks it's been taken care of. So I'm going to do those numbers, 1270 through June, 166.41 for a total of 136.41. The check, according to Bettina, is 1,320, so there's about $150 shortfall will need to be dealt with.
I believe that number is through May.
Through May? Okay.
That we have 1410 right now, and that's not including any court costs.
All right. Well, I'm going to do this through May. Is Miss Sanders still there?
Yes, she is.
Well, she's not here. I wish she were. We could discuss this, but go ahead and this happened in the last case. Keystone had cut a check which was for more than the amount of the rent, and they expect it to be there. So we don't really expect to be issuing the writ. In this case, there's a bit of a shortfall even through May. Then we get into June and we've got all other problems. But I'm going to use your number, Mr. Becker, 1270 through May, 166.41 in cost for a total of 1436.41 through May. The check is in process. We'll see what happens, but in order to stop the writ of eviction, the entire amount has to be paid. So there needs to be some further communication. I don't know if you're going to do this or they will, but we'll usually, Mr. Bradshaw, Mr. Fleeman, simply email or fax a judgment.
We'll do. I can send a judgment, Your Honor. Do you have the address I can send that to by email?
Yeah. I don't want to put it out.
Oh, certainly. I can call in, Your Honor.
Yeah, that's fine. Okay. Anything further on that case?
Yeah, if I may, just for my property manager at Edgewater, the differential has to do with a difference in filing fees, and we had to reduce it by 140.
All right. Well, we'll see. Yeah, they have 1410, and you reduced it by 140. All right, so we'll go with 1270. All right.
Thank you.
All right, you'll submit a judgment.